Jesus claims that the financial, pharmaceutical, and biotech companies put stubborn, arbitrary, and unclear federal circuit interpretations of disclosure doctrines in Section 112A reaffirms those claims, generating enormous industry uncertainty. Fallout 22 is no offensive. Part of industry is measured directly making investing billions of dollars in individuals, except for predictable direction to commercial business, applying a disclosure to consider valid possible, to be mutual plan production, all but killed, and value farmer, biotech companies, and federal scope, and talking about other plans to go to the score more disclosure, courts, market, how much, and what type of disclosure files, and developing separate doctrinal and written description and tests agreement between judges about FNDC's fundability is the nexus of biotechnology and chemical innovation. The largest barrier is the enablement doctrine for ladies 22 enable subjects, unique optical, rounding, exceedable, and other issues to couple to webs. The FCA direct barriers spending claims to a group of molecules, which is key of features of interpersonalization, util recently claimed life satisfying enable companies relying on graphic strategies and rituals to protect investment lessons of strategies market, costing $3 billion, claims central protection for result of your company taking the worst FCA technologies, the scope of development with technical control, worthless decisions and codes, and all the chemicals for protecting claims to bill, to identify the intended purpose of development, takes the responsibility of guarantees of the nation's of American federal disclosure, equals not carry evident body activities such as the countries equals the land with, Canada, good countries with the vote, and companies that put together the countries and enable to provide justification guidance, assessing both the nature of higher art, or scope of dependability, direction worth it, running is almost going to experimentation, adventures, and petty, which you have to abroad claim a full family, crucial aspect invention in the past, of course, accessibility, safety, being funded, national wants, simple appointed, subtle shot generated FC, I guess I see the FC's part disclosure research of papers and the application for the species were fatal events, and patents against doses for every species, the awareness of patents prevented within their own bodies, association, or classifications, and every regulatory executed, goes to the court upon the FC's important invented on rules and statutory basis, causing disruption, rampant judicial rulemaking at the federal level is the root cause, completely forfeiting statutory basis, and Supreme Court precedent for ladies 22 notes, essentially both were, as he previously held the claims of violation, and he says unjustly targeted impact, and the ones of violation and her derivation too high, is more viewed as stable to industry judge created, obstruction to innovation, American leadership, caps diseases, bioterrorism, Chinese influence on the last DNA storage and gene editing, and Kelly 24. U.S. Constitution, nature of national security, ensured about democratic principles, the artificial energy crop, fortification, election, influence, and flying deficit, critical to air drug discovery, discharges, economies, national bioweapons, genetic experimentation, and surveillance, leadership, and economics, weapons, discharges, financial security, surface, use priority area, these environment, manufacturing, CPT, the biology, shipping, and wave that, and commercial biotech, U.S. star revolution, biothreats, future pandemics, or inevitable extinction, Board 21. She's here of access to be managed by the entire benefit of big risk civilization mitigation, involves responding in buildings, the threat is not reduced to death of human viruses and fatality, notifying authority to use the likely gargantuan push the threat of security single or and can affect by threats, risk increases the BWC is not related only, keep on for 5 to be catastrophic biochar causing extinction cost, 20, fighters can spend kill quicker than anything could, if it should be introduced by the funding attack by the efficient biochar could be skilled enough funding to edit it, in fact most available bioweapon, China will weaponize biotechnology extinction, more 20, because Russia could do China use of their budget of turning catastrophe on nuclear wars against budget, in China uphold the nuclear China's catching up with the U.S. Beijing from national and the U.S. China's role in pharma cut more at pharma gene editing stops extinction bonus 19 gene editing regarding extinction eradication of which do not exist eliminating these crystals of artificial gene editing no acquisition and species of adaptive crops reduce pests and invasive human activity conversion but to provide a solution to extinction of extinction bolster eco health biomedical innovation stops telomere erosion pure states shortening telomeres inhibit aging the genetic features impossible to create telomeres not shorten cells divide infinitely telomere erosion cascades into rapid aging extinction central 14 all species 90.9 data the reasons are internally with lineage and durable reduce fertility shortcomings regeneration substance erosion the decreased fertility species and species the either stabilization of through consistent controlling clock triggers economies responsible 99% of species events can be triggered suddenly in 17 within a short time frame. Their issues harmonization enablement undermines American credibility, stymieing its global IP agenda, in particular in NGL helping U.S. lose the value of credibility to negotiation and giving companies less production to short standards of production, less developed countries, and the hard to accept pharmaceuticals, novel industry, effective requirements, India, and to share the fund areas to enact production for informal investigations that represent the refusal of the company to do business standards, and the digital use and body found and enable U.S. argued that India's failing to stand the obligation for enact production, not acting in firms and harmonization, trouble our future innovation, doctrine, production, and validation drew attention in the global north, and American-led IP regime spurs global innovation and secures technological leadership as L23, being thought enforceable use first IP considerably weaker for American companies help RW, reduce incentives for innovation better drugs, advance America's leading advanced industries, economy, and nations we cannot be trying to seal IP through the leadership and recognize harder time using agenda, less global innovation, extinction around 20 tech major about climate and And issue human driven life, and take responsible also assume that teaching networks leverage to offer innovative solutions, sort of leading after tracking risks, add advantage in the approaches method, much market only little imagination to future leverage the future planning the world of problem, among ignoring inequalities of environmental degradation, hunger, poverty, oppression, digital environmental pollution, crossing, open desertification, no drugs and distorted solution, only cascade new era that benefits people in the planet, technological arms racing is inevitable, only an American advantage to trust in nuclear war, 2021. Capabilities can return to negligence ability, trying to arrest invention, project capabilities to use, means to change technology made into innovation of the public, and GPT or virtual such as central lines, and neighbors to greater Russian handle assertive, trying more assertive, and Taiwan uses India, China, Japan, and access, reflecting the company version, China, threats at the US, and in particular, Russian to Bob, and targeting new economies, Russia, China, and sovereign countries, attacks with the US hypersonics, and defense, DMs. And there's and Russian weapons by two super soldiers, Russian power to terrorists around nuclear Moscow, invade Eastern Europe, China, invade Taiwan, ACS more account of extended company, like Houston, and property the big place where some company do check increasing conservative repetition, understand Washington neutral regional installation goes, and company defensive build back on extension from the greater conflict. Vaccine diplomacy turns India into a regional superpower that shores up its global influence on non-traditional security challenges for us. Nothing. South partisan vaccines of all accounts and the people video and sentiment and public global vaccine original license, not protection protect software community club, not community aid, political touching just had no bargaining affiliated to image pandemic affiliated evil of disease, resist attack of non-nutritional challenges like access to food, health, medicine, safety, really strong national state, predicted outward regional power from growth, body, life, sensibility, of the leadership, piece away, and a dominant power, Indian soft power that contains disease, eco collapse, cyber, and AI extinction. It's around 21. India could be a part of Asia intelligence or global including health, climate, and national and maybe support multilateral leadership concerns in the cyber and AI that India's only country can act as a civilizational state. Biotechnology prevents Indian food insecurity. It's the most effective solution. Version 17. You can offer your space time and be second security most of the hypercenter vultures using zero share India budget. The approach of reading fermentation to understand Nigeria contributed nutrition security and reading highest for yield of faster technology farmers that affect economic against emphasis alleviate poverty by helping small farmers scarcity will collapse India new core declare 20 in populous potential over pendencies depending on the territory because the state collects in war chief completed over associated conflict in Pakistan is going to start posting war in Asia conflict escalates to World War III Hennigan 15 what are the amazing food Asia under Russia wars and turbulent wars the food crisis once again is a whole and effective against the population of otherwise or other crisis being politically each regional health and production of circular resources countries go to war over scarce supply finally solvency reverting to a jury-based case-by-case evaluation of Gina's claims is key Falati 22. Current laws will take a neutral if extensions take lower parameters for emission, enable it to create a diversion method according to the close aware, and then time where the disclosure of the focus on disclosure strategy, managed certification, enabling person to skill using examine also case and arbitrary rules calls for automatic flexible, aversion predictability, and a flux, all items into the original formula, for nature, maturity, predictability, method, and skill, or person can do environmental, enterprise, language, first education focus on the kind of information to turn to the well and shelter, and fully characterize and test the level of qualities and location vision, not the ESC, no, changes the law forthcoming, thus the plan of the United States government should significantly strengthen its protection of intellectual property rights by restricting the enablement doctrine.
I think that's it. Okay, I'm gonna wait for that.
Yes.
protect? Copyrights or patents?
Patents. Patent.
Okay, yeah, like for what in those? Like, what are genus claims?
So basically, genus claims are just a type of patent where you claim a specific type, like a biological form. So it could be types of molecules, chemicals. It could even be a vaccine. It's just something in the biotech sector.
Okay. How does the app solve?
So the uniqueness claim we've made is that disclosure requirements right now are too high. I.e., there's something called the enablement doctrine, which is basically the concept is the point of disclosure is in order to enable another person in the field to use your patent in order to make new innovations. But the problem is that the Federal Circuit has announced a new interpretation of this doctrine on its own without citing statute that says that they have to do so much that they have to cite every single molecule, every single gene, and every antibody within the genus claim. Now the issue is genus claims have like thousands of molecules, antibodies, and biological substances, and so it's impossible for companies to, one, know exactly what they could be used for to describe every single thing, and two, know exactly what they're protecting, because the goal in biotech is to protect as much as possible, then innovate after you've gotten the protection. That's for advantage one. So, lowers the disclosure doctrine, because otherwise these patents will be invalidated by the Federal Circuit. And then the harmonization advantage is about, how this doctrine is upsetting global norms, weakens U.S. influence in other countries.
Verify they'll be invalidated on the grounds that those patent applicants haven't disclosed enough because the standards are so high.
Yeah.
Probably, yeah.
Probably, okay. Can you explain how you solve advantage two?
Yeah, so the first card, Habib, says that the enablement doctrine is causing conflicts between US and India's IP law, and reversing the enablement doctrine would stabilize that.
The point is that enablement is such a big issue. It invalidates like nearly every single biotech patent now. And so that makes it seem like the US is under fulfilling obligations, which weakens its ability to influence other countries in IP. Because it's contradictory, they'll call them out. India's historically done this, and other countries, will say no.
Okay. We'll use the rest of the Can you look at it? Very good. Okay, this makes sense. While it's being said, can I use the bathroom?
I'm gonna go.
accidentally sent the last.
11. Final.
Top rule for must increase the penalties for violations of IP strength means increasing auto, and all for strength means violence increasing protection means enforcement of exclusive economic rights, document for protection, intellectual property, and enforcement of rights to recreation, different others from EC. That requires damages or an injunction, and if 21 to receive enforcement EC, damages or an injunction violation, they do it by negative or limits legally, modifying increasing IP right protection, untenable app errors, and all modification, IP administration, eligibility holdings error negative on a massive total with unlimited mechanism. Next up is a call out conduct, but without reference to the laws of the United States, the United States Judiciary jurisdiction, the enablement doctrine assaults and competes protecting IP under non-statutory common law violations of the above. 21 common law is judgment developing legal rules of the guidance for legislative composers, dependent law, statutory IP journals, and law strength. For any level law, reduce procedurally from the operating rules and also less superhuman to touch with one side. Use all legislative information judge to carry over more generally. I mean, jurisprudence proceeding in opposite direction last week against legal thinking of benefit, thinking crime, and genius. That is the common law. The kind of direct authority for independent judicial lawmaking from statutory incapacity. Rob 23. The court held the actions with the federal common law citing legislative representing Congress with the statutory scheme and parallel common law under that Congress should address the need for courts disappearing new federal to unlimited common law rational husband undercut the justification and delegation of a federal law to say rights of the other rights of law would be suitable would address the same kind of relief and provide the common law with full statutory gaps after the society much of the incorporating the common law without warning actions full term the courts not active recognize the common law on the margins creating law legitimacy resulting with declining those out revitalizing judgment common law self-extinction so you're turning procedure generation law to include litigation legal document based on which claims to the court important governments under the environmental interests or arbitrary manner the legal claims to protect future generations including the court designating normative requirements of law under answers of reality and uncertainty ability of rigidity of the law within favor the holders of power courts and criminal government taking out predictive measures and total guarantees that domestic cultural level interpretation course and take a long-term perspective the due diligence of the stem from common law doctrine the illegal avenues left in the public trust imposed duties and state-led common law number autonomy are still pending contemplation whether disputes ready to take a political question common law block the lawsuits in the U.S. circuit courts are turned non-binding and not into judicially enforceable by the sex of whether plaintiffs the word to expand those obligations and in a meeting of solidify holding states liable next office theory new after radical fairness and clash by obfuscating ability for the negative context of case of plaintiff to specify the federal branch that carries out the plan they didn't key to agent cattle unstable links the trade-off of holdings that reject the app next up the United States federal government should determine the promotion of the progress of science and useful arts pursuant to Article 1 of the Constitution does not justify systemic protection IP the counterbalance says a constitutional barrier to IP for allowing any exception overturns the counterbalance system wide IP being all layer 06 explicit text want to indicate the internal implication constant of protocol to promote the science rather than regulate event effects outweigh the conclusion the little to justify the legal courts generally examine the individual aspects of interpretation and allocate IP enacting the constitutional together all IP statute and without the whole system is like a constitutional law so in order to agree the same for all IP legislate the patent skill cybersecurity draw 20 competitions one of the nations the patent search make weakness competition multiple studies so competition encourage efforts to improve cybersecurity monoculture increase the vulnerability to cybersecurity multiple projects include general information security increases and competitive increases a monopoly software more well failed to accept for example the simple vendor open use system failure monoculture is especially concerning of blacking out reaching authority these are closing dangers of creating many forms of puzzle competitive technology central is cybersecurity cyber tactical nuclear 19 and cyber NCD which justify the use of nuclear weapons anti highly vulnerable engagement on receipt one of the strategic stability with nuclear installation cyber tactical provoke the greater potential in the fog of war those receiving might launch weapons immediately on serving can jeopardize the nuclear deterrent and by inserting and confusing signals and his own nuclear weapons and his own nuclear weapons. And next off, the IP protection is driven by a march for control. That it was six design means restricting the most protection today, the social economic structures, cyber ideas, and subcode, guarantees self-control, the high duty status, economic social principle, organizing IP. Apparently, the word production dependent on the controlling colonizing, use the wide digital divides the two things that believe in existing codes. The code is right description can be owned property creates a common by side. Society goes possible to form a corporation based on the security to try to create artificial security right barriers and conduct which is security. Produce a common content should be civil society, the corporate world tech companies, contradictory practices, ID, limiting resources, the desire for control ensures planetary misdirection, but negative to project enlightenment, rationality, and favor intuitive ethics as the last way out. In between, for all we want is meaning, we can clear the way we destroy the metaphysical truths, enlightenment, centrality, priority, reality, and ultimate intent, knowing the way when we become a prior to the question of knowledge, connected to intelligent technology, destroy the word because it's the word of material. We can medial for our nomads, system, immediately to extract physical, legal, and determine the value, let me see something, educational model, for giving our guidance, and general career, explaining detail, what is this career, philosophical sharing, we ask what's a possibility, 6 hearing my 2017 question, when does the life needs so inevitable, I also autonomy of hyper, the subject conversion, conversation about people class to eliminate what we're taking over random challenges, research on key inequality for the rubber beauty means in nature fields, to be on a really sensitive research will have the fire vocation in the future, does have to be like that. Oh my god. Be like this. Next up, the United States federal government should create a voluntary corporate social responsibility requirement. It says if said requirement is met, the United States federal government should restrict the enablement doctrine, counterbalance also spillover, article 2 raise ethical content obligations to the government and engage stakeholders encourage to return to these behavior favorably and responsible approaches here. The RPR stakeholders, non-stakeholders, alpha factors, demand, conflicting obligation, damages, smaller quality obligation, customer, society, competition, lower prices, consumer welfare, legalistic view. Also, IP provides its convenient means to cite the important strategy, innovation, ethical issues, challenges, insurmountable competition, applying its certain related boundary attributes, IP, intangible, non-obvious, make it difficult to assess, negative impact, often disputes, indirect, today, long term, or impact of IP, greater potential to use, defined by words, do not have the clear markers, real, tangible quality, outside, use strategic, gain, possibility, you, ambiguity, unjustly, derived, exact, which is very accidental, vice versa, always continue companies to fulfill duties and stakeholders never been more relevant. The information protection, pandemic, technology, food shock, short, wealth disparity, supply chain, depression, inflation, of certain regional markets, of innovation, integrated access to firms, as pervasive of society. Do you want me to read this, or can I continue?
Read this.
Next off, the court is looking to revive Lochner, but it's holding back to the lack of clear precedent now. Cold turning where Roberts Smith and the history speculation over resounded. Resurrecting Lochner, Fitzgerald is the Lochner looking Roberts were again history essential. Controlling principle coverage of the top line after what to do. Case holdings are bedrock of infrastructure provide straightforward simple metal confident revelation courts. Renew the regulation differential study cost obsession. Noted the court overruled and focus on rights applying to no economic regulatory differential laws that interfere with liberty. For economic regulation, there's no historical analog economically new. There's no meaningful comparison between precedent laws and 1971. Corporate action IP provided clear representative for Lochnerism. Schwartz 03. Lincoln in IP and their champions of Lochnerism. IP echo the original scheme. They sought to intend common law central to principle to positive legislation. Lochner error judgment made the same arguments now made in calling for judicial aggravation to provide a return of law to destroy the administrative state. Extinction, positive safety, and use of law at the state. Updating regulation hearing for Congress. Agency regulate broadcast power providing the response to several law making. A bullet in the check instrumental and the financial parts that regulate food drugs. Irreplaceable the power that administrates is an optional. It's indispensable. The advantage. Trade is declining. Trump without every commitment in our economy is taking from escalating trade tensions. Nobody cares about the Supreme Court precedent. Trump ignored court orders while the court ruled that he had absolute immunity. COVID thumbs, no pandemic. You might said 23 times in Washington about pandemic close everyone needs to reach out. Everyone isolated for the internet. Research of station tips and nuclear submarines. Bunkers. The virus needs to be machine without feel that we need to avoid medical system. We have to maintain until it. Despite the selective pressures towards the less lethal variants, you need to find out a basic measure. No vital impact limit. 18 development infectious agents and controlled by management. The hurdles on complexity. Unterror requires considerable knowledge and financial support. And environmental experimental work. Carefully regulated genetic and realistic consensus. Automatic single ones. Ruin the experiment. Engineering virus, difficult to fight, vulnerable liver, international, non-released loss of fitness, no origin in the bioterrors, and no impact to Chinese biotech. That was answered about no gene editing, Rubis 18, empirical evidence for any clinical application would be unsafe, modified genes, spread of foods, foreseeable cause with modified genes to make sure that pathogen of time virus therapy because due to complexity as well. To make sure we protect the impact of modified genes, no telomere explosion. The evidence is from 2008, so it's thumbs telomere and telomerase. These enzymes also saw in the study. It's about mice, not humans. Urbanization advantage. Pursuing AI dominance as a fool's arrangement prevents useful collaboration and undermines global stability. Unleashing rogue AI, creating a self-fulfilling prophecy. Extinction, Grello, and Trello 25 competition fair to zero sum. The real life children off China with a weaponized advanced and rogue groups who created product destabilizing society, bad extreme organization more likely to abuse with little hesitation if it has asymmetric nature of I to difficult to prevent and tournament both cannot be winners of the competition continue to go to be severe undermining global stability. Selling scientific advice leading towards dangerous technological privilege. This part of the polarization threatening international people also about potential benefits AI promise and winner takes all over the global cooperation. Focus self-fulfilling prophecy by escalating conflict, holding spirit and troubles, and he joins on direct dialogue with the regardless of collaboration, even past cooperation continue to be a partner, TikTok may be a favorite of his efforts with China, in relation to less confrontational trade, AI competition, global peace, and extreme issues of AI guarantees extinction, solid, legal thinking of leading research, selling the lower the catastrophic roots of AI, so we create this standard really rapid advances for the social, societal skill runs on par with the influence surveys that tells the top AI research as human extinction CEOs, because the technology puts the global to the AI represents sensor with users, with activity, cyber attacks, global law, broken, extreme skin access consequences will be dire for every AI which races or AGI will be cause catastrophic harm to those AI accidental intelligence given how many humans AI will have deadly toolkit available cyber attacks by AGI will be misaligned accident agenda by design to bring goals and incompatible with humanity goals will be inscrutable and misaligned by default because the ally that's all the technical world no one knows how to specify goals of classic research relevant no technology impact that was inserted above no hedge impact Fed waste 20 the proponents had really real and the faith of one evidence that the US has told us that the picture of the world remain equally peaceful by the US conduct forces states or free to go to war with the US government choose not to their stability exists with the unity it doesn't know no Indian soft power it's stopped by COVID and this Bakari 13 essence of opportunity how the Indian soft power well help the community not be ruled toward a role play by Indians
Okay, got it. This one.
It's already in the doc.
Oh.
Yeah, it was below counterplan.
Wait. Below which?
It was below.
the CSR counter plan?
No, it was below. The United States federal government should strengthen protection of potential works by restricting the enablement doctrine.
Okay. Cool. Good.
Yeah.
List everything you skipped. You skipped civil law, right? Was there anything
Wait,
else?
could you speak louder?
List everything you skipped. You skipped civil law. Was there anything else?
I see. Yeah, the enablement doctrine one, the suite,
Which one was that?
the one after the cyber attacks, like the patents bad.
So you skipped, yeah, that civil liability.
Okay, yeah, sorry.
Is that it?
Yeah. I skipped the ITC counter plan
Okay.
and
Constitution.
Constitution.
That's the national American government.
No, that's different. The Constitution counterplan is determine the restriction of enablement necessary to Article 1, Section 8, Clause 8.
Okay.
Skip national government and skip the K, the fertility K.
Okay, cool, makes sense. The like USFG should determine the promotion of progress in science. This one does not claim to solve the case, right? It just bans IP.
Yeah.
Okay, cool. Then I want to ask about common law. So why is judge-made law different from statute, or different from a legal rule that is still binding?
Well, the legal rule that's binding has the judges interpret that law. Common law is
Yeah, I
different
understand.
because judges are making those laws.
Right, I'm asking why that's still not a law. Like, how does it compete?
It competes because courts are not interpreting the statute.
Yeah, like what part of the 1AC requires courts to interpret statute?
We think that IPR requires that.
Okay, sure. Then the CSR counterplan, why does one instance spill over?
We think using CSR in a bold new field like IP spreads it out overall. Like our impact card is specific to CSR and IP being weaved together because it's
Okay.
not been utilized in IP yet, which
And
means
then
that
social
companies are
responsibility
violating
is just
CSR.
that corporations feel like an obligation to help the environment.
They don't feel like they have one. They have to oblige in order to get the protections to plan.
Okay, but only over the plant, not in other areas. Why does it cause corporations to suddenly want to be socially responsible for other reasons?
So 1AC uniqueness is that companies are like in the trenches because they can't get protections.
Just biotech companies.
Yeah. So biotech is a large field. So then whenever
Okay,
you apply
so
CSR to every
1AC
single
cross-links we
biotech
both
business.
agree it is only about biotech companies.
No,
You don't
because
affect other
no,
companies.
it's not. Every company can meet the CSR requirement and then get the same protections as the plan.
Right,
Every
but
company.
1AC uniqueness argument is only about biotech, and then you just said that
Right,
it would only
like-
spill over within that sector.
No, we think it spills over in IP broadly.
Why? Why do they
Because
like,
companies
look at other
see that they
companies
can
and
get.
But they're not bound to the requirement. Companies that aren't affected by enablement.
What are you talking about?
Companies that
Yes, they are.
don't do
They can
biotech
be bound
products.
to the requirement too.
Okay, sure.
We're gonna take a second. Stopping prep, T55. Okay. It's going to be case and order of Venus Plains organization. And it's going to be UAPs, T penalties, common law counterplay, the patents counterplan.
The
C-
ban patents.
Yeah, yeah. The CSR counterplan. I forget the name, but it's the one that like intellectual works, or it should be named with. Then the K.
Can you repeat the order?
Yeah. UFs. T penalties. Common law counterplan. Ban patent counterplan, CSR counterplan, the intellectual works counterplan. Okay.
One more second. Go ahead. Yeah. One sec. Yeah. Input you want.
Okay. Are we good? Oh.
I'm good whenever works.
Me?
It is penalty. Okay. Okay. Everyone's good?
Yeah.
What is C1? Our impact did not hedge and nobody cares. It's totally relevant. What is C3? Yes and no COVID times. Our is about future pandemics that are inevitably going to mutate, and also the re-engineered pathogens from AI and bioterrorists. No, yes, pandemics impact their evidence. Assumes the world would have effective responses like vaccines and biotech is necessary to adapt to future ones. And now, yes, bioterror impact. The bioterrorists are get their weapons from other countries or are funded by rogue states like North Korea and Iran. Independently, China will weaponize AI against the US, which has a distinction. Yes, gene editing. Their evidence says, quote, at the moment it is too safe. Our point is we need to innovate. That's also uniqueness for the app. Now, yes, Homer's impact is long term, which is the reason that has not been done before. Now, the harmonization advantage, no AI turn. This is incoherent. And the plan is not to develop new AI. Regardless, pursuit is inevitable. The evidence says Trump wants to pursue it, and none of their evidence says us not having tech leadership would stop the AI race. And if extremists want to launch AI inevitably, then they would just do it. And the plan, the tech leadership is relevant. Russia, China, and Iran already deploying AI to kill robots, and they're doing massive data fielding, and they've already pursuing AGI. That means the impact is inevitable. AGI is inevitable. Reverse 22. A bunch of money and those advantage groups to navigate. Google's Palm and Delhi E2 consult airspace 22 prediction media Asia with 55. They don't want to official time of the beat for 8 years old. And the space videos 26 algorithm investor in 2019 rate 86% actually prediction we would be 29 breakthroughs in Asia would be surprised if we had 80% said AI is on the rise trend. Said in the next decade, version experts harvest around 29 actually will be. Then occur around 2030. It doesn't be misaligned the constitutes AGI. Look at the century brings results in the essay of the impact of far more the actions today. Experts 75% property 30 years of property essay would be the next experts actually mark the card at 30 years now. Now yes, tech impact. They didn't read the card with the code evidence does apply because the argument isn't that tech is always good or bad, but rather that we need to maximize innovation in order to solve new existential threats. Go back to the story. No AI extinction is 23, although AI versus less understood that understanding the super pregnancy and remaining of the belief will the vote and she's wasting some sort of energy. It could be human greatest allies now. They've also dropped tech leadership that's necessary to stop it. Extinction by stopping revisions or upending extractability. Yes, India's software. It's not done by COVID being future. Otherwise, India's software would decline because people don't see them. As a biotech superpower, there's also dropped food insecurity that causes extinction by collapsing India and drawing Pakistan, which causes nuclear war. Now, new apps are good. Testing data is not coaches, encourage innovation. Of course, quick thinking, which portable skill, rejecting team is archery, instant fact checking. And during checks of use, independently, a spec is wrong. We meet with users for specification like virtual base, which is unprincipled. Arbitrary release agent candidates to decent research worst case. Default to response the race of bomb. Now, team protection, we mean the plan. Strength protection by doing injunctions, damages against infringers. It's quote, all but impossible for companies to protect their patents. That's velocity, even if we lose the interpretation plan of vacuum. It's most objecting non-arbitrary standard counter to strength and protection. Means helping the rights owner manual 18 for structure. The database of every estate depending on company, kind of copyright training, representing the reverse being the protection of IP rights of decision made is required the rights. But property protection representing the remedies of original considered to be strength and IP prevent when Afghan interpretations exclude helping the rights owner contribute. Topic literature into stored ground because every advocate wants to help rights owners do particularly arguments is a huge database of every IP case. It's mostly precise. And about domestic policy functional and strength their often rights being offsets and capitate process with politics and benefit courtiers, legitimacy and court capital reasonability. Caused by here now the common law cabinet firms do well, firms in the cabinet firms in fund. And the cabinet of issues, cabinet specifically be tax and function good Afghan. Germany's objectivity can't solve the courts, can run anything at any time with zero basis and statutory, a constitutional law, upending company interest, and scaring everybody in the world. Common law constitutional destroys S&P and judicial legitimacy, court tax, even constitutional law, but the public measure against constitution, the power of conservative tax and culture. For the purpose here with the power of the fabric, S&P, the percent you settle reason is what the judiciary, a consequence of added odds to the world will more good. The judge will give him more likely the judge will give advice to have more harm than when it raises interest, or more powerful words doing anything but discretion in the beginning. Absence not be squared against judiciary. Certainty is key. One, innovation, stable, predictable patent law is supported by technology. Otherwise, companies will opt out of risky new investments. Less quality. Two, credibility. Developing countries will exploit uncredible U.S. commitments to strong IP, whittling away American influence. They need to see the U.S. is ingrained in statute to see that they're actually applying the trick, because that's what they assess when they look at terms agreements. Now, when it says doesn't spill over past ruling stuff and no impacts, it's one to list with no scenarios to scratch your pandemics and forever to solve by bad tech innovation, and they don't explain how they solve any of their impacts. Courts are worth force regulators. They have no knowledge about policy making and being able to make decisions without referencing statute is also not key. Now, the patents can run to both terms of the counterpart, terms of client, and the counterpart versions patents are good specifically in this instance. One certainty companies will jump the ship if they can't recoup billions of dollars in investing in U.S. exclusive rights to commodities. Two flag companies will shift their operations abroad, stymieing innovation in the U.S. to commodity. The alternative is worse. Companies will shift to trade secrecy, saving disclosure from innovation, patent drive innovation, and it's empirically proven by the past 10 years because we still have innovation existing. No large cyber tech that was funded non-state access, and states lack capability because it causes damage to the technology, but somebody should be the one going to versus citation or cyber tech states. I'm saying that espionage working the U.S. opponents of no interest in capturing cyber tech, markets hard at cyber tech, and monopolies aren't inevitable. Interests will stop them, and monocultures will be solved by new entrants of market from patents encouraging innovation. Now, the CSR kind of terms of growth, terms of the counterpart, terms of the plan, and counterpart versus terms of the counterpart. Then the plan, it can't solve this. It's incoherent. The plan does not ask anything of companies, and you can't hold the government responsible by binding them to voluntary CSR. Say no. The counterpart doesn't create trust in firms who would agree. Or go 24. The strongest argument against open innovation are purchasing the goes to cheap practices and firms that have trust. External parties assets and IP. The trust is centered on open success, open innovation. Strategy voluntary requirements to CSR fail. 25 period of CSR with the executive authorities tell identity the existence that anything much of the authorities themselves that these things make the practice or something like the executive. Ensures that CSR is private person domain. And reserve the government if the Congress doesn't fiat the plan that say no by the federal judiciary. They are helpless and retaining super enablement doctrine, which destroys companies' innovation regardless of net benefit. Is also solved by biotech innovation because it's all about the environment, which is solved by new innovations. Now the other counterpart permits both permits the counterpart permits the plan, and the counterpart versus permits the plan. Counterpart then the plan now caused by all the other deficits from the other page. And intellectual property works scare companies that currently have patents that are being invalidated. They're afraid that other companies will go and take their patents and if it's a new IP system, they would just refile other companies' patents in the new IP system, which means everybody gets their patents stolen, or they're just afraid of making new ones because they're unsure of the new legal system, regardless of net benefit. It's wrong. Advocacy fails being 22 benefit letters. Expensive hair problems that advocacy that would hold over the highways in a particular company, and highly systemically everything or no because of insurance of going to be considered heard it's such a standard purpose feature. I've probably the bad news received no printed officials as it's a reality issue arbitrary over churches. And epoxy can't deliver public goods held 18 diamond governments an effective adjustment climate change and host evolution dividing unequal price problems cyber food insecurity and quantities and migration server and systems are pressured for words happening for percent crowded and starts to use such and we're unresponsive bills and transit policy. For example, gun control and now the K framework on the web is not, but it then tells Wayne the case have the links to plans the identification for unprincipled case that's been granted clash. There's turns the all because you can't research or permutation to both permutation to the all and non-mutual suits are parts of the alternative conditionality is voting issue excuses to see instance and changing creates like radio debates and disability solves permanent theory check often voting plates or voting issue is what you see. Words events on millions unprincipled pride questions non-use of PPI is voting issue logical but doesn't spirit the resolution solves the private active PPI. It makes after impossible extinction outweighs. And no link IP is not control, it is for protection of your own individual rights. The alternative is people will lose their rights over their own ideas, which is worse and denies agency because people can't protect themselves from other harms and people the lead and the government will be able to steal other people's patents like they're doing to biotech companies. Go back. Do you have more cards for anything else? Can you get me that? I'm reading it out of biotech cells, DNA storage, extension, control 21 DNA, how typically copies of evidence, high density, no entry points of best speech, concept, work info, and new skill, minutes, years, feature, generation, extent, only. If extension data will be saved for millions of years, go back to the social works kind of plan. It's inherently uncertain tribute to the use speech as the negative to become absolutely based in social cognitive opinion. Already complicated operator interpretation. Speech lacks clear balance and eligibility preempts existing IPR and leads to endless questions about rules and use cases that applies to Canva because effectively saying OD 93 is something better. For speech is difficult but any video we have prohibited how the interface and how to system be defined for clear regulated interface and how to cover and accommodate any unclear situation. And second issue code is that it be approached critical issue we have a scope of protection and encryption the purpose of the person to research and be presented to the property and would be instructed to leave the available campus of license for caution to avoid the hyper technology and I've heard of money spent by interest groups. I'll send the add-on out.
Oh, wait till
Did you send the AI?
Yeah. Okay. Alright. Okay, every product brought up is there, and also perm text are in the documents.
Okay.
Are you good?
Yeah.
Let's start on leadership is good.
In biotech, not hedge.
Okay, the Kronig card is pretty explicit about.
Oh, well,
US
that's not hegemony. That's us catching up to revisionists who are developing new technologies that will upend strat stability.
Okay, so other countries are ahead right now. Why don't they solve the things that your ALF is?
Because, well, they're ahead in other technologies like AI, like robots, like quantum computing. All of those are different than biotechnology.
Okay.
And also, our evidence is specific about how American leadership is necessary to utilize these technologies for good.
So other countries are not utilizing it.
Yeah, like Russia and China are using it to attack US.
Okay, so the claim the 1AC is making is that we should assert the US's like own leadership in tech so that the US has broad control over technology.
Not like broad control, but I mean, they would.
Like, or
assert
I guess the
good.
US standards for technology.
Sure.
Okay, sure. I want to talk about this add-on. Where do you think this talks about extinction?
Well, it solves other like any extinction threat would be solved by this because we could just put human DNA into a storage system, send it to space, and then later we could come back and boom.
Okay, we already have DNA storage mechanism. What part of the ALF makes this different?
Well, I mean, our 1AC evidence says that we need to innovate those new methods in order to store them for longer. The DNA storage systems we have now are
Okay,
things
but
that
okay,
have
I don't
chills
get
for a
the
long
claim.
time.
The Kesher card
They're
is just like
different.
PCR technologies can create millions of copies
Not
of DNA.
PCR; those are actually different.
No, your card literally
polymerase
says
chain reaction
PCR
is
creates
something
millions of
different,
chain.
but,
Okay, hold on. PCR creates millions of copies in a
Yeah,
few minutes.
so-
Why can't we just use PCRs when we come to the extinction level?
Well, because we also need a way to store that DNA for a very
yeah,
long
but
time.
if it's like created in seconds in millions of copies, then why can't we just do that when the threat comes? Like, why do we need to store it?
Wait. It's not like we can just go like, okay, everybody get in the room. Like, we're gonna take your DNA. There's a nuke coming. That's not
Okay,
how.
so your claim is like we should put DNA, like we should store DNA, put it in a satellite, and then like when we go to extinction, we're like, well, let's get our DNA from the satellite, like
Yeah.
repopulate the Earth.
Yeah.
Great. Okay.
I mean, it doesn't require people to go get the DNA from
Yeah,
the
like, it would be
satellite. We can set
automatic.
up a satellite system to
Who
like
stores
come
the
back to
DNA?
Earth and repopulate humanity.
I mean, anyone can store the DNA. It would likely be the U.S. considering our scenarios about U.S. biotech.
Okay, and whose DNA is it?
Like anybody who wants to go. to
Or if you get a
space.
card that says that people are willing to like.
Like
run
once you make that
themselves.
claim, we can have a debate about that. But for now, I think this is sufficient.
Okay, sure. Can you talk about the certainty deficit on common law?
Yeah. So we have a couple. The first one is that the concept of allowing the judiciary to not cite any statute allows them to make any rule on their own, which effectively makes them policymakers instead of allowing them to interpret law as they're supposed to. There's two implications. First, companies are afraid that they'll make unpredictable rulings, like the federal judiciary did when it heightened the enablement doctrine. And the second is it obliterates the separation of powers, which is, it's been accepted for like literally forever that, courts cannot make decisions on their own about what policies to implement.
We'll take we Oh, on the K you said it ruins the alls. Number 3.
I didn't say it ruins the
Oh, something.
Oh, sorry, yeah.
Oh,
it ruins the
oh.
all because of clash.
Yeah, okay. Reason to reject
Yeah.
K theory and Congo.
Yeah.
K
Congo
theory,
on K.
Yeah.
K theory being floating fixed, non-USFG fiat, and private actor.
Yeah.
I'm sending it. I'm gonna send it when everyone's here. Actually, one more second. Alright. It's sent. Order common law. The counterplan that was like creative over intellectual works.
Yeah.
The critique. Advantage 2. Advantage 1. Oh, sorry. In between dissad and critique, CSR, and then the manpacks.
Okay, so common law, lock here, CSR, then counterplan, okay, advantage 2, advantage 1.
Yeah.
I'm good. You?
One second.
Jordan, Tyler, Taylor. Yeah, cool.
The capital was the account casing creates accurate protections on the basis of judicial doctrine, not patents that creates remedies identical to the app, and a protection scheme that's perceptually similar but developed from case-by-case judicial enforcement that's Bangladesh. Use sufficiency if you cannot isolate the impact resulting deficit. It is functionally zero. Perm do both. Firm issue no 1 error perm clarification. The 2C with 3 words. And fluctuate is predicate off of 2C missteps. Use offense defense. If the counterplan solves the majority of the case, any errors perm fails means you vote neg. It also does not solve. 1 is displacement, saturating law and overlapping errors. Ensures that courts construe the counterplan to an extension of the plan that is insufficient to create precedent. For judgment, common law that's Rob inserted for reference. Second is that the perm is statutory gap filling and fails to expand federal common law that's block. 11. There's widespread government common law must be grounded in federal law limitations that the court must bind to a federal enactment constitutional statutory. The interprets authorizing the rule is to also be limited filing gaps in statutory scheme. The court has recognized the authority and limited errors to formulate federal common law. Those in which Congress examined the court's power to develop the standard of law. The source of statutory gap filling guided by Congress is the most common controversial common law. The source starts from jurisdictional statute. Second is preemption. Bangladesh 9. 10. The regime preempted by federal IP law. These errors want robust operations against federal preemption IP law context. The regime strong in significance. Structural attributes are independently beneficial. Congress silence followed by enforcement of utility. This regime marginality common law hardly contemplates structural features. Congress sees virtue in these processes evidenced by carving out the same face of them. That ensures the counterplan does not create precedent. Manual 11. Make search of IPR law import for statutory interpretation applying IP courts to trace the origin of statutory text or doctrine in order to determine whether common law to focus on statutory text legislative history with codification statutes implement purposely judicial doctrines of development of codified law patent law enforce bring to treatment over common law. Perm to the counterplan framing issue value competition on mandates not endpoints otherwise 1% risk means that no counterplan is competitive. Purpose severance index near ground voter for fairness and clash. 1 is IP rights. They're statutory and distinct from common law. Adler 24. Common laws embody normative rights. People will have over time statutory may recognize or create IPR. Second is strengthened. It must increase enforcement of the relevant statutes. OSRGOD 2K. Strength of IPR protection which IPR laws must be examined. The measurement of IPR incorporate both as a statute component and enforcement component. Enforcement practices range from having no enforcement, having strong patents, copyrights, and trademark IPs protected under laws. And the third is protection refers to domestic. Actually, skip that card. Courts are topical, but only insofar as they're interpreting statutory commands. Assignment of 14 meaning of laws firmly established to exclude courts insofar courts are laws. Now, other issues frame the perm through around the sufficient solvency for that benefit. Courts are risk averse and try to minimize precedent. You should assume minimal deficits of the perm obviates its presidential effects. That's Rob. Inserted for reference. Second
Second is a controversy. Only the counterplan alone creates a controversy sufficient to create broad precedent since it explicitly bans statutory IP over the app, permits a distinct area of law. While courts will assume authority derives from statute, there's no sovereignty applications which sees you air and ag. The case is key CSR 7 under Article 3, jurisdiction limited to actual ongoing case and controversy. From this comes justifiability. A case must exist throughout judicial proceedings. Second is dicta versus holdings. Even if the firm retains a claim of statute independent common law, that claim will not set precedent. Number 1 is certain 5. Even punctual judges should not be found aware of the gender authority to resolve legal issues. Even a judge's claim should produce a holding be able to challenge the same from statutory issue. Concerns agrees. Actors agree upon definitions holding dicta. Future courts follow holdings and consider dicta can only be helpful. Mark and helpful. Now, functional alone. 1 is ground where host process counterplan. Third, 3 huge top theories who know you find a ground. Ask and upload status code. Remain topical and more. Second, word game justifies getting in that benefits with terms score germane and non-germane that benefits deletes all counterplan. Third is logic, technical competition. Distorts opportunity cost by ignoring meaning and rewarding plans off street. Fourth is sexual vagueness. There's no incentive to specify anything in the plan. Because it makes it easier to permute things. 5 is plan jamming. It distorts opportunity cost with semantics and teaches logical decision making. 6 is textual topicality. Textual topical class like state should do the plan would be logically allowed. Those are functionally extra-topical. Since you have all the words of the plan, concede reasonability off the topicality as well. Now, the deficit. 1 is comparative evidence. Core flexibility ensures companies perceive common law are more favorable and adaptive for future innovation. That outweighs certainty from statutes since there's a notable uncertainty when interpreting those statutes. That's 1 and C Bangladesh. Second, their deficit is our point. We fiat the plan, which means that it's not going to lead to unpredictable judiciary definitions. Their SOP card doesn't even say the word common law. Courts also solve all their offense. Common law is both durable and predictable. It's on 22. Statutes interpreted against backdoor common law. Either legislative or court doctrines ruling made by higher courts or president controlling in lower courts, making each powerful and durable. Judges enjoy autonomy and IP protection. Statutes preserve judges' autonomy. Judges adapt doctrine on a case-by-case basis, ensure reuse, develop and applied by judges. Royal statutes not codified by judges. Create develop new doctrine after less with constitutional norms and public interest. Promote technological advances. Deficit certainty. No. 1. There's no distinction between the app and the counterplan. Fiat is not perceived. Common law rules are more certain for businesses, not lawyers, since they're developed by enforcement. The plan's effects and enforcement are only known ex post. Since interpreting statutes 6 years of jurisprudence. Also, I forgot to say this. We get functional competition alone against the UAF. Second is durable fiat. So also their offense. It's reciprocal. Ensures the counterplan scope of protection is identical to the app. There is flexibility outweighs and certainty. Bangladesh 10. The legislative process takes time to prone to interest group pressures resulting in gridlocks. They high level certainty. Compromise flexibility. Common law rules for rulemaking situations. Serious decisions and this constrained freedom process also forces courts to proceed with high. This is the law. Mark at that. There's also no sovereignty deficit or links to them because it's inevitable. Moscow 19, Congress enacted statutes, courts used its Supreme Court's common law, courts created a new class and rights and statutes, courts extended rights by judicial. Procedural doctrine was creation not solely by the courts interpreted and applying statutory provisions, constitutional doctrine become the law. This is applied by the courts, mark at courts. The impact spills over and outweighs the counterplan common law creation over an area explicitly not protected by the statute creates a precedent that spills over the statute independent common law that's key to the success of future gen lawsuits which feel unstanding now. It creates government accountability which solves pandemics, AI, nuclear war, that's still and it's key to environmental protection suits which were all dropped. Now the dissent concede admins say no impact, we're not going for it. The counterplanes concede perps not going for it either. Now the critique, no condo, counter trip, we get what we did against new app. 1 is neck flex, topics not bias. Strengthen any industry, apps flat stable mechanism, topic dissets or scarce. Second, arbitrariness, non-receiver interpretations are raised at the bottom, which spreads that substance. 1, skew inevitable T, cases at speed. Second, DMU, adding more upskis. Rules such treaty liabilities, this was bad. 1, consensus is on. Second, can solve metrics. First, permit 3 and 2C dictates block neck. And third is logic proving the counterplan bad. Does not prove the app is good. Now, the harmonization advantage. We are straight turning the entire advantage. Westwood did not understand the turn of the 2C. It is US dominance bad. They read pronate, which says that tech leadership is good, explicitly at the end, which means that anything that passes China causes adversarial tensions. There's no AI impact, which is relevant. This is a case turn with no defense or uniqueness in the 2C. US tech dominance, loss of extinction. It prevents research collaboration by the US and China, allowing for weaponization of AI by malicious actor that outweighs. 1 is extremist AI uses. Thousands of top researchers estimate an extinction level threat, malicious extremists, and rogue states will use AI for cyber attacks, bioterror, and other catastrophic risks. That's Leib and Goldstein. Second is existential conflict. Pursuing AI dominance brings a self-fulfilling prophecy, undermining global stability. Winner takes all logic brings polarization and escalating conflict that threatens international peace. That's Braylon and Trullo. Third is that third is good AI. Only US-China collaboration can mitigate the downsides and maximize the upsides. That's Braylon. Dominant shutdown scientific progress. Now, collaboration low is wrong. 1, our scenario is collaboration, not cooperation. They dropped that this turns all of the offense. We do not need to win the US and China are best friends on all issues, just that they're collaborating right now. Second is Trump. He has restarted direct dialogue with Xi regarding AI collaboration and wants a less confrontational trajectory. That's Braylon and Terrell. Third, they're locked in an AI embrace now. Just saw scene 25. Pack like a rivalry in AI from being locked in tech where their two nations are closely linked with AI research collaboration driving innovation. The other major lead research co-wrote 46,000 papers on AI creating shared foundation. For next week, through partnerships between university collaboration, contrast simply with the narrative and market. CFC from concerns, yet the data tells a more complex story. There's undeniable competition, commercial space, research partnerships thrive. Now, there is no other impact, no food wars, fast 18, little merit that food increases conflict, violent conflict requires people to have the means and will, most starvation of a position to resort to violence, discontent, more complex, linked to land corruption, democratic forms, economic research has shown will immediate tendency to seek resource explanations. Debates are complex, statistics disprove this. Cliff 16, research is not clear link between food insecurity and conflict. Link is indirect. Countries face food price shocks without falling into conflict. Simplicity to adjusted with driver of conflict. conflict countries have institutions that will help. South Asia stable, heart rate 20. Their stability based on improvable record deterrence. 5 crisis in India reacted with caution. Operations were strictly limited to India part of territory for fear of escalation in the Twin Peaks crisis. New Delhi refrained from. The Mumbai Prime Minister quickly ruled out military response. Attacks were met with carefully calibrated during 2019. Both were conscious of the need to avoid escalation. Market escalation. Now the genus advantage. There is no impact. COVID thumbs. It spread a highly dangerous disease, but it is limited due to islands and virtuals. If bioterrorists can develop weapons, then we can also develop vaccines. Do not check out on the fact that their cards. Do not assume our offense. They're clear that no matter what extent they're right about bioterrorists, it will not cause extinction because we're resilient. Scientists are skeptical. It would never reach anyone. People are at isolated corners, ships and subs and bunkers. All take it out. There's also no bioterror impact. TOC does not explain why bioterrorists are any different and can get the same resources. There are no card says that DNA would cause extinction. Risk is 0. McDonough 22. If the agents to be manufactured for a large-scale tech and specialization necessary, there are challenges across the biological tech difficulty. Weaponization makes biological agent hard to provide population. The risk of bioweapon is still very difficult to produce a reliable biological weapon. Nation's best stockpiles. Variety vaccines were to be denied. Bioterror filled with failure. That's bomb. Yeah, that's Blum and Newman 20. The threat of bioterrorism was one of failures. The challenges to weaponize biological agents proven insurmountable. Not one is that for biological agents, but legal biological agents trained by trained actual full access lethal biological agent, which is more difficult than sees. You cannot make a weapon in the kitchen. There's challenge of perfect conditions.
Good for cross?
Yeah.
Okay. I want to talk about the turn. This does not make sense to me. So your evidence says they're collaborating now over AI. The researchers are working together despite tensions. What evidence says that the U.S. continuing to develop AI upsets that collaboration?
Well, our cards say that China is safe whenever the U.S. and China are working together.
Yeah.
Whenever the U.S. leapfrogs China, that's what causes.
Evidence says the plan
arms
makes
race.
us move away
Your
from
1AC
China?
card, like we
Where?
conceded.
Pull a line.
Okay, sure. Let me go to your 1AC. Okay, I don't have the 1AC open, so take a while. But you read Croning, and then at the end of the 2AC,
Okay, so
you
your link
explicitly
is
said
you
technology
read the
should
author
cause
of
extinction.
Croning. Like pull a line
No,
from
no.
our evidence though.
Yeah, Croning is about leapfrogging China because China's
where is
China's
it?
revisionist.
Wait. Yeah, that's true. Where does it say that the U.S. continuing to pursue innovation stops that
That's
collaboration?
your
evidence says, quote,
solving.
despite tensions, they're still collaborating. How
Yeah,
does the plan
those
upset
tensions
that?
are uniqueness for the term.
Yeah, there's tensions now. What evidence says that this plan breaks those tensions?
Your 1AC evidence.
Where does it say that?
Your 1AC evidence is about.
Like,
What is
hold
the
on,
evidence literally
hold on.
says Russia is dissatisfied with the spread of the U.S. alliance.
Okay, so Russia is not China.
I have a question about permanent counterplan on common law. What's an example of ground that only applies to statutory court acts that wouldn't apply to a common law-based court act?
Like, can you repeat the question? Why don't
At the
any
end
court
of
dissents
permanent
apply?
counterplan, you
Yeah,
said
why don't any
immutability
court dissents
justification.
apply?
Yeah, you said
Because they're still
that
interpreting
AFT
statutory
have to be
means.
statute
Yeah.
because you lose ground versus acts that are common law. Why is that the case?
I can't hear you.
You made an argument that AFT should be forced to interpret
Yeah, you have
statute,
to alter
not be common law,
statute for it to
because you
interpret.
lose ground.
Well,
What
again,
ground
they don't
do
have
you
to.
lose?
You don't have to alter statute directly, but courts can interpret that statute, and that is still topical.
Yeah. I'm asking, what ground did you lose if a plan does a common law ruling instead of one that interprets statute?
Like court dissents?
Why? It's still through the court.
No, but it's through a different process.
But like, what court DA is
And
not statutory?
and potentially dissents to Congress as well.
How?
Because you're not interpreting statute.
Okay, I'm gonna go back. Your JASM evidence says, quote, this relationship is a balancing act, a mix of rivalry and cooperation. Our evidence says that they're already locked into a tech arms race between each other.
Well,
What does the
again,
plan
we've
change
read
about the tech
cards to
arms race?
disprove that.
What?
We've read cards to disprove that.
Does that say that they're not in a tech arms race?
Yeah, they're collaborating.
Yeah, you can be a tech arms. Your evidence just said that they're in a rivalry and cooperating. Why does that prove that they're already in tech arms race and can
No.
collaborate?
The rivalry part is uniqueness for the term.
What? Explain.
Because you need to balance the relations.
Okay, what
It
evidence
is
says that US
strenuous
and
to
China
plan
aren't
leapfrog
racing to
China.
individually develop
Your
AI?
1AC card.
What?
Your
That
1AC
evidence says they
cards.
are both racing to develop AI.
No, our cards say that they both like AI, but they want to develop it together.
Yeah, what does the
which
plan
solves
change
your
about that,
impacts.
though?
What?
What does the plan change about that?
Yes, your 1AC evidence says that.
Yours just okay.
Okay.
Is anyone?
Alright.
waste. The drive for control is an unsustainable death march of planetary extinction that want to see perpetuate favoring of paranoid securitization, fueling the fantasy of intellectual mastery is a quick fix. This rationalistic view produces constant extraction and results in waves of natural blowback and violence that make extinction inevitable. Instead, we should refuse it and every turn framework. The role of the judge is to escape the will to mastery, adopt the maxim that control-driven bigotry is bad and vote accordingly. Never have its hurts or interpretation. Revise the will to act in constant 25 freedom to respond to humanity action too much and thought too little. That yet to understand the source of the cultural prediction may because will to action has first thought require the long-term response to be still unbelief the imperative will medalize the age of feeling imperative act or give up that which issues anxiety, worry, and limits and disheartening constant 25 the state of much culture needs to act as an deeper ontological predicament which we have not uncorrupted. This will generate new difficulty along with anxiety, upside pressure. We feel to control and everything and recognize the guiding humanity later. Respond to them thoughtfully so we are not reactive, leaving us underlying preconditions examined covered. The cause less alarming curiosity, anxiety provoking tried by believing response is control even wording concern alarm disturbed and disheartened. Second is inductive reasoning which destroys human agency. In 11 including being dominated by ideas of array of human endeavor work really war writing access untraditional reflection of pursuit efforts to be deleted encoded actively track of encoding agency is a pain echo coming of certain reports which is the binary code of becoming ignorant in etymological statements the citizen of circumcised diligent by alternatives which is an oppressive which cannot access other meanings. 4 is externalization. Feels compulsion to displace destruction ignores an internal war culminating to a will to violence. Capital 94 will to violence dedicating itself to political issue except in everyday thinking or opposition will to violence constitute mobilization will take destruction will to the war leading to powerless to the political still end of said we are not responsible to misleading I think we have no responsibility we present organized responsibility of holding that parallel connection between real together individual organized democracy will let them burn inside of the way that shape our feelings framework framing issue their interpretation causes endorsing the right to control which means voting negative is a deontological side constraint magnitude outweighs if we're right if there's a risk for right voting app imposes a model that results in psychological suffer if we're wrong we make a structurally ruined activity slightly more unfair. Our interpretation is also based on core justification. They said IP and tech good. We impact on that premise, but there's no impact first. If only competition mattered, we'd be elsewhere or it's global. Teams are app. They take 50% of the time, which checks on second on unique win rates or 60% skewed in elite England. Socioeconomic means resources equal more wins. The judges would never bias 3. Westwood knows this and debates anyway. That justifies wrecking the game. If it's reversed and competition beats counter empathy, context company is sensitive to other competition beats counter empathy to feel it later. Other failures to arrest says there's context of human goes out of the group. And the reason they want. And the only reason they forward for why fairness matters because they want it or we want it too. That's exactly the format described. Self-interest, the entire case impacting me. They'll mention the fairness paradox here, some of our own. How did for general rules effect would have the effect of cause. If the public had established either without the previous attainment, or the other without national politics more generally, violence of course in the name of the law, periodic company, concealed by the foundation of all the self-paradox, environmental empirical paradox, so by the public, not to generate rules of the consider. Now the clash in the first is strict plan focuses worse creates utopian alt not remain opposite, so there's no intrinsic model balance to the model. Second, the absolute solve or links to the justification of the one to see the render debate into a method of control. College to overnight legal information as stable order of review is been a predictable way tool for order deliveration all search for precision is the real function of all which we educate a laws are instructed family terms of which steps to educating a multi-interest now the link they haven't contested the thesis of the K which is means automatic neg ballot IP makes us detached from the world by looking at objects instead of human action the app defined by a cybernetic ideal that controls and exploits any intellectual resources that commodify society and nature that's related that's a desperate need for control build hidden illusions that breed instability presumption 1120 world open illusory world of security certainty by running anything just circle based on exclusion fiat restricted the microchias of holding service level of viewers compensated with the losses moving or inconsiderate right over review highly pressure if there's a sense of something wrong these might become liability we're building beyond desire to retain control over weights multiple fragile forms of vicious cycle threatening to we're giving responsible as an unsustainable structural spell the athlete produces the very system it proposes bankrupt till danger drives into laws that something might go terrible and wrong with everything will just smoothly was threatening prospect with the human journey could be modified with any undesirable side effects in that case man would have transformed himself into an entity that could hardly be called human it's a metaphysical illusion to believe that one control the development technology through regulation man is not the master of technology to be able to guide the future but really and that a merely stretched present hydroton remains a product of epoch speculativity but strangely enough because the fact that the unaccomplishable will actually nullify the distinction between subject and object unintended consequences actually they say IP is not control they read the link for us the quote the protection of our own individual rights specifically in the context of controlling the dispersion of our version of biotechnology no denial of agency its impact trying to treat everything as a means to an end which precisely it's the inclination to dominate and control the world framework obviates that you should escape the will to mastery under any calculus DNA is 0 it's long-term PCR at that point it's also just put it on ice the impact is immeasurable actually permutation to both first framework obviates debate should be about escaping the will to mastery second the link framework said that was above the ultimate ethical paradigm not saying Europe policy action allowing acceptance destroys agency not a floating pig USFG or USFG fiat or private actor it's a rejection of the will to mastery in favor of intuitive ethics and rejection that quote the US should have tech leadership for standards across the globe quote that other countries don't use tech correctly quote vaccine diplomacy and quote storing DNA for perfect future generation the alternative is an intuitive ethic it puts exploitation on pause by refusing the will to mastery in favor of an ethic of fair a humility and appreciation for nature on its own terms. Want to see Pippin says the ethics solve the case we respect adversaries don't use things like tech weapons and mean environmental goals but any depth that misunderstands the scope of the debate. Pippin says that at skill there's no immediate alternative to the market but that such tragedy not ought to be depoliticizing instead quote conversations in classroom but quote eliminate a path forward you should understand this process the exact process of philosophy etymology the love of wisdom entails a commitment not an endpoint similarly you can feel comfortable voting neg without a concrete step-by-step plan for solvency because it's the very process of slowing down to contemplate and give with the will to control that the alt solvency actually occurs itself the embrace that we cannot control everything encourages humility and global cooperation with solve all of the artificial scarcity of innovation they've dropped the alt you should assume it overcomes any reason open source innovation is bad this isn't a band tech love it 77 not creating some of the past of no focus technology of the they were destructive backing out rational thought solves Thompson 25 being entity recurring wills of direct forces, moving as other forces know and beyond the perpetuation of force, and unifies our age intelligently conceive things, and doing those resources to be quantified automatically imperative Prometheus. Mark the word of Prometheus.
Okay. It's 8:51.
Okay, there was something between if only competition mattered and elsewhere, and win rate was skewed 60% off. Confirm it. What was that?
If only competition mattered, we'd be elsewhere, or it's global teams
Yeah,
are
yeah,
out.
okay.
Yeah.
That was it.
Future pandemics cause extinction, they'll rapidly adapt to overall defense, culminating in global extinction. By turn, cause extinction viruses will be engineered. COVID does not thump, it does assume engineered pathogens or adaptation. We cannot make effective vaccine without biotech pathways, which slows their work. Telomere erosion causes extinction. Our chromosomes will slowly become shorter, instilling rapid genetic deficiencies and extinction that's trapped in the 2C. Now, harmonization, the AI chart is incoherent. One AI is inevitable. Revisionists like Russia and China are all developing and deploying new technologies that they'll leverage as get hotspot those go nuclear. They dropped an impact to pursue this inevitable drop that the US is ideologically held on to tech leadership. Critics of the conversation is already happening in least escalation unless the US secures leadership. They drop Russia and China or revisionists. Three, cooperation is inevitable. Their evidence is so apt. It says the quote. It says quote the relationship between China and the US is a balancing act, a mix of rivalry and cooperation. Others that arms racing and cooperation can happen at the same time. They have zero evidence to dispute why the US and China are both pursuing new technologies. The plan does not change the way that they pursue them. It just increases the rate of use innovation. The LM evidence. It's even better for us. Quote. Despite tensions, US-China AI research collaborations are alive and well. Clearly, arms racing does not trade off. They also drop that the impact is inevitable. AI will inevitably misaligned or exploited by rogue actors. That they have cited in Italy tech leadership stops extinction. Revisions will often charge stability with key technology like drone swords, AI, quantum computing, lasers, terror attacks, text that stops environmental collapse, offering new solutions and stopping desertification. That's the wrong evidence. And Indian software stops extinction from disease. Equal collapse, cyber AI are showing up. It's multilateral influence in Asia now. South Asia is not stable. Doesn't assume social stability. Terrorism, civil unrest, rising population, which all collapse India. And now they also dropped no AI impact, which was carded in the 2AC. Now common law, part of the accountable is the crush. It's a possible means to the plan. 2AC1, they said mandates, not endpoints. The accountable mandates the plan if we win the below definitions. They said, quote, we fiat the plan on the certainty deficit, and proving that common law still protects IP sufficient in term of fiat is law, and the accountable still passes the plan as law. 22, IPR to statutory is wrong. IPR includes common law. August 24, IPR means having common law structure of the rights. That's the most common meaning. Yeah, the community intellectual property for common law. The court sucks. It says statutory enactments, quote, may create other rights. So does IPR, but it's not saying that they must be. The strength and definition is in the context of measuring the strength of IPR, not at all would constitute strengthening at all. They dropped 3C Mandel in a product and Mandel cited studies and all past IP court cases that strengthen IP and said that any action involving the rights holder means predictability outweighs the guide scrap and arbitrary limits. Cost shifting goalposts that kill clash and fairness, they'll fertilize. They'll incentivize frivolous rule creation which tunes engagement will concede arbitrariness from conduct functional competition in Afghan ways. They emulate our exact mandate but pick out a legal rationale that forces us to impact on their turf. Nobody writes common law key and lack of comparative literature allows them to sidestep billboard questions. Destroying education, no debatability, offensive lit-based, functionally the light-based constraints explosions, and nobody thinks that common law is prevalent in IP will concede that they get functional combination and infinite condo. They said this solves ground and flex, making the debate easy. They get core themes like clog innovation, like key taxes, and criminal law, and have the blocks of card dump, and skew the 1AR document can also not list any ground. So you should not limit something into an hour, no statutory gaps, durable fiat insurers, good faith implementation, otherwise every gap lose to rollback the 2C. Did not answer that benefit defense is a laundry list, there's no scenario, scratch with pandemics, an environmental solved by biotech innovation. The court does not explain how it solves any, and the courts are worse regulators because they have no knowledge about policy making, and being able to make decisions without a reference to the statute is key. Deficit is massive. The common is a departure from predictable law grounded in the statute that upends reliance interest. That's the 2C evidence they drop. The second deficit, the TRIPS agreement, international IP looks to US statute, not to courts to determine whether they're fulfilling obligations. The counterplan is a departure from that. Insight to its influence is that companies refer no evidence and they won't. It's wildly out of line. Fiat on the plan is relevant because the process is uncertain. Courts do not solve their office look wildly incredible. And even if common law is predictable in other cases, it is not in this one. Yes, distinction. Fiat does not need to be perceived for companies to be worried about whether the court has gone off the mark and started legislating for the badge. Flexibility is wrong. The court says legislation fails in other instances. The plan is Supreme Court and accurate inter legislation. The deficit is not linked to us. There's no warrant. And the plan is comparatively more certain. They drop the impact. Companies will opt out of drug development. That's Falati. So no new office. Now the critique for the vote solves all the impacts in the overview. Otherwise, it's inevitable. They have no ability to solve them. No political fix. It's unfair. Framework with it. The fiat consequences of the plan against a competitive all links so unique. And the almost defense solvency. The interpretation forces them to prepare for every section of the library and have a defense of every representation. Address or speech talks, process, moral character, etc. Fairness always is a power question. They rely on a two of flowing speech and asking you to adjudicate their arguments on a technical basis. Otherwise, what happened for the only impact. The ballot saw executing a procedural remedy, winning the violation index to debate, happening in the first place. Presume affirmative decking competitive equity means that you cannot determine the strength of the critique without first determining whether we should have been prepared to debate it. Will concede arbitrariness and non-risk from the flows. The framework is one, so procedurally strikes it. Framework solves long-term responses. We will learn policy advocacy. Thinking about the problems is good. It makes us more likely to solve them. So no subject formation. Though don't believe anything we say in debate. Induction is real. It's incredibly likely that induction will not fail in this instance because even if induction will fail sometime in the future, our past experiences do inform the probability and likelihood of success in the future. Point 3 is about the law, not rules in debate. Point 4, no fiat cates. Inevitable they see fiat to the right since there will always be those that attempt to do so. Empirics of iteration persuaded debaters to practice mutilations and sanctions. Fairness, defense, the activities key to solve their offense. In fairness, no hard question. No global fairness is only about this round. If they're right, the only competition matters, which is why we're here. K-debate is an overcorrection, cause masses to unite. And win rates are close to 50-50. Judge biases flip both ways, and even out of this round because we voted perhaps no competition breeds counter empathy. If they're not competitively motivated, then voting against some competition is a mighty force that brings us together. Self-interest links to them because that's a deontic statement, not a utilitarian one. Good luck explaining these paradoxes, causes, contempt effects, and the uncaused cause of the universe itself. itself or a God combination is inevitable. They partake in the balance, does nothing to cause change. Because debaters recoil now, maxims fail. It's trivially easy to craft universalizable with bad ideas. They put blind trust in leaders to correctly apply moral rules, even though they can justify gratuitous suffering to face a national honor or liberty.
Student actors have tried for control, combination, and planetary extinction, and they've conceded uniqueness. That means it's try right for the night because each of these were dropped. This sets to the plan. Do not risk any inclusion in the outfit of the perm because you know the alt is more self and alone. One, the 1AC exemplifies algorithmic thinking that channels itself into intellectual mastery as a quick for global problems. The impact is immeasurably large in scope. The presumption of control and rationalization causes enemy cycles of blowback and violence. The impact is concrete. The search for technocratic control creates a quote extractivist relationship that will quote terminate our viability on the planet. Pip, and that categorically outweighs the case. Their impact only serves to saturate our desire for control, refuse that presumption, and embrace the intuitive ethics of the all. View this as a conceded sustainability warrant. Case cannot outweigh if planetary survival is doomed inevitably. Second is value to life. Drop. Thompson says that technocratic maximalism, managerialism turns humanity into a numbers game. Each individual is only worth what they can contribute to a paradigm of stabilization. The app does not understand what it means to be anything at all. It only contributes to a recurring will to power. Now, framework. If we win it, dismiss the entire case. The 2ER will be new and unwarranted, but the 2EC was clear that the critique is prior to the evaluation of the consequences of the 1EC. They must first demonstrate that their compulsion towards control is justified before the endpoints of the control can be weighed against all of our impact. Their interpretation requires you to invert the order, guaranteeing error application. I know you probably don't want to judge Heidegger and TOC semis, but the 2EC was a mess here, and the 1ER mishandles everything. The role to judge is to escape the will to mastery. 2 frames. 1, they've dropped their interpretation, embraces a drive to control, which means you have to vote neg as a side constraint and seeks to bracket out ethical questions regarding the relationship to the world, which systems that they claim to address in the first place. Foreclosing that dissent is a tactic of managerialism that links all over offense. Second, magnitude outweighs drop. If there's a risk away right, voting off imposes a model that results in psychological suffering that must come before either fairness, because it's the only thing that we leave around with. Our offense come first. Extend the will to action. Dissent. Also drop. Trying to act on future threats forecloses our ability to understand the sources of our technological predicament. Their interpretation, quote, overruns and crushes thought. And it says that we need an alternative that does not steamroll beneath that imperative. That's all Thompson. That outweighs all of their fairness offense. Their interpretation requires action without thought. Prioritizing fairness at the expense of critical reflection stagnates both debate and us into strict rationalism that fails to grapple with the complexity of modern technology. Second, they've dropped the in-round impact. No new answers. That alarming state brought on by the plan is an anxiety-provoking trap and leaves us worried, concerned, alarmed, disturbed, and disheartened. If they've dropped it, it also inhibits us from deeper thinking, which guides humanity, which turns a case, even if it's not offense, it's 0-0 offense, because their interpretation does not produce critical thinking that they espouse. Instead, it forecloses fairness by preventing discourse on issues outside of our control. It means the fairness paradox is also relevant. We do not think that fairness is bad, but we said that the abstract desire to maximize has negative externalities. 2NC Callister was also mishandled. Do not check out on the fact that this is not about debate. It says, quote, functions to maximize stability and predictability are part and parcel with the technological nature that Heidegger critiques. Their interpretation serves to turn resources into a tool to be, quote, ordered, quantified, marketed, and consumed to a calculated end. Fairness is wrong. There's no link. They dropped our interpretations based on core justifications. That means that there's no offense about every section in the library, etc. Arcade does test plan desirability. We have not pulled authors or unhighlighted portions of what I see, but we've tested their IP and tech good warrants. It's also not a floating pig, which means it's relevant. Do not vote on perm to the alt. Cross by offense and above. It's obviated by the entirety of framework. Dropped our thesis. It's also okay of fairness. They've dropped that the fairness paradox feeds into the form of ascribed self-interest that are in case impact firm that also breeds counter-empathy by forcing debaters to prey on the failure of others. Competition without intuitive ethics causes dehumanization. That's code. This is not about us not being competitively motivated at all, but the maximization part of that and the fact that we use competition for bad reasons which they have not grappled with. There's no non-restricted cross application. This is about the critique, which disproves the desirability to plan. And offense defense appears that you cannot bracket it out. Either way, there's no impact. One is global fairness. Teams are out of 50% of the time, which checks. Second, structurally drop the reasonability cross application. When they speak first and last, there's no generics on the neg, which checks infinite regression. We're also going to concede that common law is not competitive, which also every example listed in the 1ER. Third, it's non-unique. There's structural reasons why debate is unfair. The 1ER answer does not apply. This is not a classic structural fairness argument, but the fact that if they're right about their internal link, wrecking the game is good. They've dropped examples like win rates, judging, and socioeconomics. There's no paradox either. And 2NC card says that the struggle to create a more stable political order is never finished and results in exclusion and more violence. Do not check out on truth testing either, because we won that there's no link in the K turns it. This is not just the framework K. They've conceded a link DA to the plan, and the alt, which is functionally unwinnable for them. Perp links, which is done above. The K also explicitly critiques subject formation. The entire argument is that the starting point is to forget about the modern world notions of a separation between the outside real world and the inside subjective world of perception. The alt is to rethink human existence as it presents itself now. Now, Westwood has dropped trick after trick after trick. Extend 100 lepis. It says that their worldview is a, quote, illusion of security and certainty, and links as a flat, restricted world of mechanization by trying to smooth over inconsistencies. Our card says that becomes impossible, and the unstable structure would spiral. The other lepis card says that their worldview cannot afford openness towards change and rejects anything cannot be integrated, which takes out human life. Now, end of the 1ER is relevant. We defend the denial of agency and the control of humans that denies agency as an axiomatic bad because they explode resource limits and makes flowing past planetary constraints inevitable. Biological innovation confirms technological framing and deepens alienation when framed as liberation. Heidegger says the danger is not biotechnology will fail, but that it will work too well. It makes life increasingly functionally its technique. Feedback and manipulation. The act celebration of innovation does not escape this. It strengthens it by accepting the assumption that technology is a neutral tool for when humans end. The alt solves the entirety of the case. Drop. Remember, the 2EC drops this and puts exploitation on pause and instead breeds care, humility, and appreciation. They dropped that an explicit quote that says that conversations in classrooms can, quote, illuminate a path forward. The alt is a commitment to slowing down, contemplating, overcomes any reason. Why the status quo is bad in the first place. Revisionism is all irrelevant. The alt does not stop technology. Also drop the alt encourages a policy of openness and collaboration, which obviates all their outfits. We respect each other, do not use weapons, don't get locked in managerial rational thought that short circuits the entire case.
Case outweighs insurance, your straight to decay. Dropping the case means your predictions are accurate, not from a delusional self-control. Drop. This ends the debate because every link they extended assumed that something about the plan was wrong while simultaneously conceding the full weight of all of our claims. Tech leadership is dropped. Russia, China, originally mounting invasions, hotspots, and nuclear, and all that's conceded, which means you know the plan. This stops an existential war. That is conceded. Now go to the K. The tunar drops the bell, make it the top. You can agree with every tunar push about ethics and also vote out because of this violation. I will be clear. Framework excludes every single argument made in the tunar on substance because all of those were criticism of our ideology and idea of intellectual property and assuming self-control, the idea of using biotech to be weaponized. All of those are arguments about the ideology and the ethics of the one you see, not about the substance or a materially linked thing to the plan. Our interpretation is only about when desirable the results, weighing the case consequences, and protect any links that are extraneous to the plan text. Winning this means you procedurally exclude the links because it doesn't implicate whether the interpretation of the plan is a good idea or not. The order to another only extended links representations like the phrases that our evidence uses, but nothing about the implementation of the plan that wasn't meant to leverage any representation tangentially linked to the plan that burdens the applicant answering hundreds of possible critical holdups like law, state, society, while also turning a word, phrase, and action or individually attached to the one you see into offense that impossibly research burden, which leads to prospect of permanent victory that's also unpredictable. Drop. The resolution is a sole stakes to the point and a sole burden is proof the plan should occur when the nine moves are arbitrary requirements are an ad hoc basis. We conceded arbitrariness and that non-res theory should be rejected. That does apply. The judiciary bars you from evaluating their framework offense because it's not based on the resolution. Fairness that weighs is the only impact the ballot can resolve, i.e. the remedy procedural unfairness produced by their framework interpretation. The sole function of the ballot is create a win or loss, and we're the only team with impact depending on the result. Fairness categorically comes first. Each and every argument that they make on the floor requires a fair evaluation, creating paradox, and the resolution only is to maximize fairness in every instance, and so we must proceed. The content of any neck offense, they can't win that their DA outweighs. The paradox is not self-interested based fairness. It's units of value that shared amongst all participants. They draw the examples like Greenhill spreads, read cards, emphasizing technical mistakes like they did in the 2 independently. They have no reason that self-interest is bad. Drop. They cannot explain what the reason self-interest is bad other than they assume it's bad as a deontological claim with no factual basis. The other answer was paradox causes negative externalities. Fairness preconceives that because to evaluate whether those external externalities with fairness, you need fairness in the first place. Now, no side constraints relies on anti-consequentialism. Maxims fail. They have no explanation for why things like self-interest, lying, or a general good are good other than the consequences that happen, which means you should default to consequentialism. It is trivially easy to craft universalizable but bad ideas that put blind trust in leaders who correctly apply moral rules. They've also dropped a DA to the framing and justifies factual. Justice more national using nationalism or racism to justify your rules because they're always independent goods and have no psychological suffering. That is also answered one area. We said that thinking about problems is good because it helps us learn how to solve them. They dropped that no subjectivity shift. Also implies that debaters don't believe what they say, so they want to feel psychologically harmed by thinking about solutions. There are also all causes like school, friends, family, etc. And debaters recoil when they lose and ripen a block. Instead of changing the worldview, no will to action. They drop debaters don't believe what they say. That was above. We also kind of heresy, which means you know the plan will happen or it is impossible that our debate arguments happen. Fiat link terms critical reflection. We still debated to pursue an educational form of problem solving without committing to one ethical standpoint. We're not disturbed because we don't believe in the case. It's just an institutional thought experiment that we know will happen. Now, justifications are still a one. They say prior questions in this debate. They say justifications another. They can make a question the YC's legal philosophy, law, the YC stands on the hyperreal or author's Twitter tweets too. It is unpredictable. The resolution brings us with the defense of applying their interpretations analogous to a game of saying counter interpretation only a rap. It's clearly regressive, and only the other team with a different framework interpretation would assert the same. They've also dropped this browse into including any justification because there's no definition what justifies a court justification. If they're right, then the fact that they've gone for this critique of phrases in our evidence proves that court justifications can include anything. Now, global fairness is wrong. It's just about this round. It doesn't feel love because you drop losses where the losses we recoil, no side-bys again. One error drops framework interpretation is an overcorrection that skews every debate negative because they can go for links about anything. Social fairness is ridiculous. They drop. It doesn't occur in this debate. They more coaches than us. They go to private school and it doesn't apply broadly because judges they allow judges to make violent determinations on individual students even if they deserve fairness. Now you can see that denying agency is an axiomatic bad. That proves you should vote out because we prevent extinction, which crushes agency, no counter empathy, winning fairness. Proves Greenhill is gunning for the ballot as well, and competition is unifying point of commonality. The moments and stories we share arise from the competitive setting. That's the reason they didn't drop this round to go talk with a friend or just hang out. No reasonability. Our internal proves that their interpretation is not reasonable, and we cannot. Their interpretation is not reasonable. And cannot produce a year of good debates. Common law concession proves that we have some ground, but critiques overcome it and so overcorrect. Everything at the top of the tunar should just be struck off your flow, no algorithmic link. It's ridiculous that Greenhill extended AI regulations down the block and dropped that the plan makes cooperation possible and still extended, and their impact regardless. It should be excluded by the K because it's about ideology and representation. The alt obviously does not solve the case. The one explicitly said the alt doesn't link to international fiat or any other three arguments. That means they cannot subsume the case, and that must only affect things in route. That was also extended. But their framing arguments, so that means permutation to both at least has to solve because you can include the plan and still conclude that predictions were accurate.
Get a bit.
Cards. Yeah, I got
This is the first time I seen you in real life. First time I seen you when I was kind of like behind you. And a treadmill. Hello. Yeah, they just kind of fucked up. Yeah.
Hey, Tyler. I said the number.
Okay.
Yeah.
deal with that.
The desk. Okay.
And I got these if you want to see it too.
I think so, from my perspective.
Because you don't have to be, but like, food was really expensive. No, some of them were 8. But yes, I understand. I just, you know. Well, but
1350.
Rory's not.
Yeah, that is their phone.
That's Rory's thumb right now. Rory! Rory!
Where are they? Yeah, we're just waiting for the announcement and all. At least for them. Okay. Yeah.
Okay. Congratulations to everyone who made it to the semifinals of the TOC. It was a very, very good debate. All of you are fantastic. The decision is a 2-1 for the negative.
Just like main few arguments that were covered. Okay, while I sat, I just start by saying that I thought this was a phenomenal debate. I think I judged you all a couple times, especially in this tournament, and I thought you all debated excellently this debate. I was really impressed by both the 1AR and the 2AR. I thought you all like YAF. I think you all are very clear and made a lot of good arguments, and I was just really impressed by the argumentation in this debate. I thought this was ultimately very close, and just you all should be very proud of how you debated both this season and this tournament. I voted on framework. I thought the app one that I should only consider causal links to the plan. The neg links cheat discarded because they're apps, they're links to the app justifications rather than consequences. I ultimately thought the app would win. I didn't think there was a great link to the in-round anxiety, competition, bad psychological violence impacts, because I thought the app won the argument that the next cards and description was more about really investing in will to action rather than hypothetical thought experiments of other actors would take. And given that was a large part of the 2AR press, I thought the app could win some risk debate good against defense the next one to the offense, and I thought given they were basically going for great debates, the app did that as a combination of fairness and docs and that was all that.
So I want to echo what Tyler said. You two are both phenomenal. Especially some of the privileges. You know, people do a lot of research. Thank you so much. You're constantly breaking new apps. Always have new strategies. It's great. I actually didn't really assess framework because I concluded that I thought there was like a very, very marginal risk of a link to the plan, and the problem with that then becomes that the entire rest of the critique until the 2AR is substantively uncontested. I think that all probably has a pretty good chance of solving most of the case. And mainly that just means the impact to it is huge. TOC doesn't have any defense to it. 1 yard doesn't go either. And I think like obviously, move stability for the app should really be that big. Like 1R alleges that the 1C link was to the plan. 2R equally alleges it. The app doesn't talk about the link to the 2AR. And like I think that you like you're correct in your restrictions of like some of their links, but like you never ask this like a certain there's a link to the plan. It's like just a small explanation of it in the 1R, and I kind of give it to them. Yeah.
Yeah, I decided the same as Jordan. The top and bottom of the 2NR are like pretty extensive explanation of like IP bad, like sort of marginally, and then it's like comparison of the perms and the alts, and the app didn't even have any confidence against alt. Makes it difficult. I